ప్రయత్నం.
It's 8 o'clock, Sujata. Can we start?
Sujata.
Yeah.
I will start now. Okay. So, good morning, all of you. And also Happy New Year. Let me start with a gratitude note because and this forum had not been given to me. I don't think I would have explored many areas in GST. So thank you so much. So first and foremost, in today's topic of the day, GST applicability on plotted development. So when it comes to plotted development, I thought I should understand the basics because since me not having any experience, practical experience, I went on to the origin and how the plotted developments are done, what is the business model, what are the related laws that we need to study for understanding in depth. So whatever I have studied, my understandings are presented here. It is more like I should say Hanuman service where, when herb was asked, Hanuman brought the Sanjeevani mountain. So that's how I have put it here. Kindly bear with me. So in a way, it will help those who are into practice. Whatever I am presenting, all the connected, related laws only I am presenting. So if you feel that at any point of time I am deviating, please don't hesitate to stop me. So with this disclaimer, I am starting. First and foremost is that when we want to understand the plotted development, we need to understand the connected laws. So majority of the land related laws are state laws because Constitution has the supreme power. If you look at what are the laws that we need to understand, if you ask me, first and foremost is that we need to have a basic understanding of Constitution in the sense, how does the state derives powers for taxing any law for that matter, any tax for that matter. So the statute comes from which authority of, under the which provisions or which article of the Constitution. So that we need to understand. Second, what are the rights, whether is it a fundamental right or is it only a legal right? Those things also we will get into that. And when it comes to the Land Transfer of Property Act is it's more like a mother act where anything relating to immobile property, what we refer even today is Transfer of Property Act 1882. And of course, Easement Act, Contract Act, Registration, Stamp Duty Act. These are also allied laws which we have to refer. So, is it moving? So when it comes to acquisition, sometimes we see that in income tax, at the time of filing, the compensation is paid to the landowner because of development towards acquisition of land for development of any metro construction or highway construction. So this is recently, it's pretty very young law, right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, which states that if the area is in certain area, certain place, certain location, the compensation is multiplied by certain factor. So this is what that law is about. And when it comes to revenue collection and regulation, these are some of the laws which are related to land. Karnataka Land Reforms Act, which is a very old act, not much of relevance now. Karnataka Town and Country Planning Act, which is also very important and relevant. This is also something like a supreme act when it comes to any issues or provisions relating to land. Then Karnataka land records, those are all not of much relevance. Karnataka Land Revenue Act is also important because when we are doing RERA or any legal related or anything relating to land, if we want to assess the origin of the land or conversion of land, how the agriculture land has been converted into residential allotment or anything of that sort, we need to understand at least the names of conversion or what does the document convey, because majority of it will be in Kannada. So we need to understand the powers or the conversion happens through which act or which authority. So for that we need to understand Karnataka Land Revenue Act. Karnataka Urban Development Authority Act is the regulatory act which is going to give permission. It's more like administrative act, I would say. When I say Karnataka Land Revenue is the act, and Urban Development Authority Act is the administrative. It's like GST department in simple sense. And RERA, which is also a new law. This is enacted for the interest of protecting the interest of buyers, and also it regulates the promoter or landowner in terms of whenever it comes to construction or joint development. It brings in a lot of transparency. When it comes to taxation, today our point of discussion is on GST Act. Of course, income tax also we have to learn and understand. So basically, if we want to understand plotted development, if you want to advise the clients on plotted development, these are the minimum laws. Like, at least we need to know what is what. So with this, I'm starting. First, before even getting into anything, we have to understand the word land, because most of the taxation issues are dwelling upon land, sale of land. So we have to understand the term land, where it comes from. If you look at Constitution earlier, like, maybe, I don't know, the amendment 40 or 41st amendment, land was treated like just like any other fundamental right. Land was also a fundamental right. Then later, Article 31 and 19(1)(g) was removed, omitted. Currently, it is no longer a fundamental right. So Article 300A it states that it only protects the person not to be deprived of property save by authority of law. It means that no one can be deprived of their property unless and until it is enforced by law. So this is the one and only legal right which we derive from the Constitution. Apart from that, nothing talks about any right in terms of from the Constitution. So when it comes to Article 246, why I'm saying is that there are three parts, means three subclauses. So one, Article 246(1), 246(2), and 246(3). One is about, it starts with the notwithstanding. That means the union list, Parliament has got powers to enact laws. And when it comes to 246(2), state has got powers. That's also again notwithstanding, subject to that list 3. It means that land is state subject. So when it comes to supremacy, always, of course, Parliament has got the supremacy, like, union list 1, that is the acts enacted by the central. 246(1) is the supreme, like in the sense central has got powers, but still having said that, there cannot be any encroachment, though the land related laws are enacted by state, which has got supremacy over any other concurrent list or state union list, but still the union does not derive any blanket powers. So that is what the mere understanding of 246. Having introduced 246A, which is the, under the 101 amendment, constitutional amendment, where GST was brought in, this 246 or 254 does not have much relevance, is that what my humble view, because 254 also, which states that in case of any inconsistency, how it has to be handled. That is what Article 254 says. Having 246A, which is specifically, inserted for the purpose of GST, let us stick on to 246A. And also 254 also has a, notwithstanding clause with the 246A also has a notwithstanding clause with the 254. It means that let us focus only on GST 246A subject to 265, because 265 stands independently. No tax can be derived or collected without authority of law. That means there should be, Constitution says that there should not be, a tax should not be collected without authority of law. What law, how it has to be collected with respect to GST, let us stick on to 246A. That's all the other, connected articles at present after GST, in my humble view, I don't know whether we have to think too much about it. So I'm sticking on to 246A and 265 with respect to anything for that matter, whether it is a state or central, let us not bother about all that. So now when it comes to goods and services, that's also defined in Constitution. 366(12), which says that goods includes all material, commodities and articles. 366(26)(A), which says that service means anything other than goods. Pretty much our GST Act also, taken only from here. What it says that when we want to try to understand where can we fit in land or sale of land, when you refer goods, it says all material, commodities and articles. It's like, if I have to put it in simple terms, goods, one room, services, another room. I am a land. So I am going to goods room. I am seeing whether I have an entry. I don't have an entry because it says that material, commodities and articles. So I am coming out of that room. I'm not entering that room. I'm trying to enter the services room. When I'm trying to enter the services room, there also, I don't have a clear, entry for me. But just because it says anything other than goods is a service, anything, it is not anything. It is anything other than goods. So I'm permitted to go there. After going there, I should be clearly classified where I can sit. So when I'm looking around, I'm seeing my brother, sister, or my siblings are there because I am a land. I am sale of land or I'm a development right, whatever it is. If I refer to section 7, I have all my siblings where tenancy, lease, rent, those are all mentioned there. But development right or sale of land is outside. When it comes to sale of land, I'm already outside the room because in the GST, it says neither goods or not supply of services. So absolutely no problem. When it comes to the inferior rights, we need to see whether it falls within the goods or it falls within the services. So one way of looking at it is that since my siblings are there, I should also be classified as service. But when you look at Article 265, unless and until it is expressly provided, unless and until it is specifically mentioned, I cannot assume because all taxation laws are strictly interpreted. So for the legislature to tax anything, it should have clear identity. It should be distinguishable. It cannot be by assumption or presumption, and it cannot be through delegated legislature also. So to sum it up, anything to be taxed from the constitutional angle, it necessarily has to fit in either into goods or into services. If it is not within these two, let me refer to these respective acts. If it is found there, it is taxed. If it is not found, no tax. And we have to leave it to the interpretation of court if we want to litigate. So this is the simple understanding from the Constitution with respect to land. So when it comes to Transfer of Property Act, which we all know, I think for this forum, I don't have to explain much. Anything land, attached to land, embedded in the land, or rooted. Tree is also treated as an immobile property. It starts with an immobile property. So immobile property is a superset. Land is a subset of immobile property. So when we say that what happens to the rights attached to the land, which falls in the 3, any rights are also superior, inferior rights. If you say that sale is a bigger right, all the other rights are all inferior rights as compared to sale, subset. So if that being the case, is it an immobile property? Yes, all the rights are immobile property. But if it is an immobile property, where do we classify under? Those are all classified as services as per Schedule 2. So Schedule 2 and Para 5 says that these are all services. So perfectly fine. So when it comes to development right, it is not found. So development is right, also immobile property. So ideally it's my thought, probably they could have mentioned in schedule 3 that what all the clearly list of items that are not neither supply of goods nor supply of services. It is left with sale of land. When it comes to sale of land, what is clearly specified is sale of land only. We cannot, extend or enlarge or expand it. So it is only sale of land. And towards end, building. Building is also immobile property. So that's the reason why they have completely excluded from the supply of goods or services. So immobile property is taxable under GST. The answer is yes. Land is no, it is not taxable. Anything attached to land, depending on the circumstances or the facts in hand, we have to see whether it is a goods or services. So this is what we understand from transfer of immobile property. And section 214 of the Karnataka Land Revenue Act, every act defines what a land is. It's more like the same to Transfer of Property Act, not much to deliberate. And GST also says the same. So when it comes to Karnataka, now I'll just quickly go through the Karnataka Land Revenue Act. Land Revenue Act is more like, the reason why I am, deliberating or touching upon this act is that we have to understand what is Pani, because majority of the times we see that RTC is nothing but it is provided under section 127. It's a record containing details of landholding, who's the landowner, what is the type of land. There are various types of lands are there, soil, depending on the soil and fertility of the land. So it maintains the RTC, does not give any ownership. It just says that this is the person who's in control of that. I would not even say possession. He's the person who's in holding that land. See, because if you look at originally, land was never possessed or purchased, it was granted. So whoever possesses, whoever encroaches, or whoever adversely goes and sits there, he was the person he was considered to be the person holding the land. So right from there, if it is recorded in the right of records, RTC we call it, tenancy and tenancy certificate. If it is found, then it is produced as a evidence of ownership. It is not a real ownership. It does not transfer or entitle any title to the land. So the point why I am trying to say is that many times the agriculture land is getting converted. So we need to go in depth whether he is the owner of the land or where does he derive the power from to convert his agriculture land to residential land when it comes to plotted development. And Kata is also not a title document. It is only evidence of ownership. It is not a title. So when it comes to mutation register, Patta book we call it, which records the movement of land from Mr. X to Mr. Y. So these are the basic things which we have to understand. And when it comes to land revenue, when it comes to Land Revenue Act, there are certain amendments were made in the year 2020. This is also something I'm touching upon the important points. Through this act, currently in Karnataka, even if you are a non-agriculturist, you can acquire the land. You can buy agriculture land, farm land. You can buy. Earlier, it was prohibited. Apart from that, they have enlarged the ownership. Earlier, if you are a farmer, you are permitted to hold only certain number of units. Now that also got enhanced. One more important point relating to this act is that there are a lot of litigations are resolved, because of which the many more lands in the rural area will come out for development. So this is one thing which is relating to plotted development. So since the litigations were ready, why there was a litigation? Because of ownership, and then they were saying that you should not transfer agricultural land, cannot be sold to non-agriculturists. There were so many litigations were pending. So because of resolution of those disputes, many lands will come into the market. So apart from that, these other amendments are not of much relevance. Anyway, we all know that the land from SC/ST, certain category of caste cannot be sold to anybody. They are prohibited from selling, or the buyer should not buy. So we have to ensure that when a developer develops, he does not buy any land, whether it is a plotted development or whatever it is. Of course, government authorities will take care. But still, when we are reviewing the documents, we have to ensure that the land has a good title and it is not a prohibited land. So this is what we understand from Land Revenue Act. And next is the very important act, Karnataka Town and Country Planning Act. The main objective of this act is to form a structured way, a planned way of development of any layout in Karnataka. Basically, this is a Karnataka state-specific act with all civic and social amenities and environment friendly. In the sense, every community, if certain group of people are living, it should have certain basic amenities, basic civic amenities, and also nothing wrong in having any other amenities, recreational amenities or whatever it is. Those are all add-ons, but still the basics are laying of road, leaving some space for park, post office, bank, or these are all the some of, and drainage, water, sewage, electricity. These are all some of the basic things which the government should ensure to its citizens. The state should ensure to its citizens. Because of that, this act has been enacted. So anybody wants to acquire some land and builds, he cannot do it the way how he wants. It has to be in the as per the master plan specified by the KTCPL Act. So the KTCPL Act has got some master plan. At the time of designing itself, it says that, okay, if it is a JP Nagar area RBA layout, this is how it has to be. So it should have some park, it should have some Kalyana Mandapa, it should have some post office, bank, schools, hospitals. And this is how the roads which should be, this is where the metro will come. So these are all planned well in advance. So master plan is kept in their records. Anybody, any person goes to the department for plotted development, he has to ensure that the plans that he submits are as per that. Then only he can apply for a permission. So this is specified in the section 17. When it comes to the sanctioning, the authority is also very strict. I mean, as per the whatever is stated here. So when it comes to that, it minimum things, the conditions which are laid down in section 17 are that the developer, whoever comes forward for development, it's not the developer, sorry, it's a landowner. The landowner has some bigger piece of land, say 20 acres, 50 acres, 100 acres of land he has, or he may be having small fragmented, many people may have fragmented land. One person can take the lead, aggregate all the land and go to the authorities and then get the permission. Or one person who's having a larger piece of land also can go to the authorities and say that I want to develop my land into plotted development. So plotted development is nothing but there is a barren land which does not have any any basic structure or nothing. He goes to the development authority and says that I am going to develop the land, give me permission. So the department says that if you want to develop, you have to have the minimum things. You have to give some portion of it towards the road, main road, sub road, whatever. And then you should have park as whatever I said, civic amenities and basic necessities. You have to relinquish the right of your right over the land to the department or to the Secretary of Urban Development Authority. Only then you will be given permission. They call it as a release order. Release order will be given to you for further development, for further in the sense for future selling or whatever. You will be given permission only later. Before that, you cannot sell the land. So first is that you have to build, you have to submit the plan as per the requirement. Then the department will come for survey, inspect it. If everything is in order as per the master plan and other things, you have to relinquish the right by paying the, there's a fees also. Government will not pay any compensation for giving up your land to the government. It will not give. So to that extent, the person who purchased the land or owns the bigger piece of land will end up losing it. Nothing can be done. he has to make his money only when he fragments the land and sells it to the external buyers. So, but earlier up to 2020, the rule was that you cannot sell before getting the OC or release order. But after 2020, that's what I understand, the developer can sell before receipt of OC also, release order also. It means that when the construction is ongoing, that part I don't understand, because if he deviates, what will they do? All that I don't know. But it says that once when you get the approval and start the primary, they call it as a deemed sanction. Once you get the deemed sanction, then you can start collecting the advance from the prospective buyers and start your development. With that money also, you can start the development. That's what I understand from this act. So if anybody deviates from the plans or whatever is at stipulated conditions, the project or the the sanction plan will be cancelled. So this one thing which you have to understand. This is with respect to Urban Development Authority. This is the authority which is going to give suggestions for any technical issues, technical opinion on conversion of agriculture land, and then how to expand the city, Brihat Bangalore, whatever we are seeing now, all are done by Karnataka Development Authority. This is more like functionary authority, administrative authority. For any OC or commencement certificate, we have to approach this authority. And one important function of this authority, which I found very interesting, is that they have the power to collect the betterment tax, in the sense, because of certain better amenities, say some metro has come or some mall has come or whatever it is. Because of that, the surrounded area also, surrounded areas land value also gets appreciated. So when it does so, this authority has got powers to collect the betterment tax. They call it as betterment tax from the landowner or from the person. So this is one thing. And they will always have some kind of development work, which is for the development of lake or whatever. Those are all some social obligations which will give the approval, which has the authority to give approval for such social obligations. And if you look at it, BDA we call it, and BIAPA, these are all one of the very well-known development authorities, depending on the jurisdiction, whether it is in Karnataka or Kanakpura or Hubli, Dharwad, wherever it is, you have this authorities corresponding to your jurisdiction. So this is what is all about the land related laws. RERA is more towards the regulation and controlling the working mechanism of real estate developers. So when it comes to land plotted development, we are reading about plotted development. The plotted development, is it covered under RERA? The answer is yes, plotted development is also covered under RERA, because the definition of project, the definition of the promoter, the definition of real estate, for that matter, anything, registration, everything includes plot also. If you look at anywhere, there will be word called plot. That means if you want to take a registration, assuming land is allotted, if you want to sell it, when do you want to sell? The RERA itself is applicable only when the landowner has an intention to sell. If he is going to develop for himself, RERA itself will not be applicable. The minute he thinks of selling, finding a buyer and selling it to some external customer, then he necessarily has to register under RERA. Whether he should only register or the developer, if he enters into JDA with the developer for development of the land, then who's liable for registration? It is always, as far as RERA is concerned, it is a joint liability. It means that one person can register, the developer can initiate the registration, but the responsibility and liability duties are all joint and several. It means that when even if somebody wants to develop a plotted development, even before construction, just he has a big piece of land, he wants to put only the fence, find a buyer and sell it, he also has to register under RERA, provided the conditions are satisfied. What are those conditions? 500 square meters. which is basically equal to, I think, 0.27 hectares and area, acres, and 0.5 hectares. So if it crosses that, or 8 units, any one of that, if it crosses, threshold limit is that, if it crosses the threshold, then he necessarily has to register under RERA. So one important thing which we have to understand from RERA is that RERA stipulates the model agreement also to be submitted at the time of registration. So as far as the landowner or the developer is concerned, they have to be clear upfront what do they want to do with the land. So the sanctioning authority, the local sanctioning authority, which is the urban development authority, will not be interested in knowing whether you want to construct it like a villa or apartment or whatever it is. Their job is to give the permission for the layout, and they are interested only in whether are you relinquishing your rights and you are giving the whatever as per the conditions of section 17, or you leaving the space and for civic communities. That's all. Over and above that, if you want to build villa, or if it is a twin villa, or it is a independent gated community, whatever you call it, if you want to do it or not, you should have upfront plan, so that when you are doing itself, at the time of development itself, you have to structure the contract with the developer, entering into JDA. All these are to be planned, so that you have to submit the model joint development agreement and sale agreement, sale deed also, agreement to sell. Submit the model copy of that, draft copy of that with the RERA authorities. Once it is submitted, it cannot be altered. Once submitted is submitted, subject to some minimum changes can be there, but it cannot completely, it cannot differ from what you have submitted once after taking the approval from RERA. So the point what I'm trying to say here is that if you want to design your contract saying, I am going to sell the land first, then after some time, as per their wish, I will enter into JDA with another developer or with this existing developer, construct the villa or independent bungalow or whatever you call it, then the landowner or developer should take an informed decision, because the taxation under GST will differ as per the JDA and the stance that they are taking. So with respect to real estate, one key thing which we have to remember is that with respect to plotted development, for plotted development, registration under RERA is compulsory, and all the provisions relating to apartments are also applicable for here. As far as RERA is concerned, in my understanding, to the best of my understanding, apartment is a vertical building, villa is a horizontal. That's all. Not much of difference. I don't see much of difference, because here also you have a common area. Everything is a common. Like, you have a clubhouse, common amenities, common area, UDS. Some of them have UDS. Not all villas have UDS. So depending on the contract, it is designed. But for simple understanding, more or less both apartment and villa plotted development on that when you construct a building are more or less the same, excepting that UDS. So, when it comes to bifurcation of contract, splitting into contract, that is something debatable. We will take it up later. So these are all the acts and background which we have to understand for knowing better about plotted development. The reason why I have spent almost half an hour on this is that plotted development, it is over a period of time with one circular. I am of the opinion that many things got crystallized and it has become very clear. Taxation has become very simple, I would say. So since it's being simple, we have to understand that, yes, is it really simple? So that's the reason why I have taken this much of time to understand. So this is a step which the developer has to take care before getting into plotted development. This is what I discussed. Next, when it comes to GST, now, if I have missed out anything on this, sir, I'll take a pause here. You want me to add anything, or is there anything to say here, sir?
Nothing from my side. Maybe you can continue. I
Oh.
don't know. That's if some doubts you can ask.
I'm not able to see anybody. Okay, I'm starting. So when it comes to model, see, I am a landowner. I have a big piece of land. How do I have to go about? What are the business models available for me with the builder? So first and foremost is that I am owning a big piece of land. I only approach myself to the development authorities, get the sanction, and I am selling it. So when it comes to GST, there is no question of GST here because I am just selling the barren land. I'm going basic as per operation of law, whatever is required, I'm doing and then plotting it and selling it. No question of taxability, no question of GST here. We can forget it. Next comes landowner hires a labor contractor. So what I do, I am calling some local contractor. I am asking him to do the basic leveling of land or weeding or whatever, fencing, basic things I'm doing, and then finding a buyer, selling it. In such case, what would be the taxation for the land developer? What would be the taxation for the contractor? You call him as a contractor or construction contractor. So as far as the landowner is concerned, what he is selling to the end customer is only the land with the basic cleaning up and leveling of land. So landowner at the time of selling is not rendering any, of course, there is a supply of land, sale of land, schedule 3, no GST. When it comes to the contractor, what he does is only the construction service. You can call it as a construction service or you want to call it as a works contract. I will not call it as a works contract because he, as per the contract given to me, he comes, does the work and goes. So what he does to me, I mean, I'm the landowner, is only the construction service. So he will be charging me 18%. He is eligible for taking the input tax credit. Next question comes, I am the landowner. I am not able to, I do not have any idea about how to go for sanction, what are the formalities involved in it. So I am engaging a expert who's a real estate developer who will do end-to-end for me. I am entering into a contract with him saying, I will bring my land in the form of partnership JDA. I am bringing the land, you do everything for me, development, finding a buyer, selling it, plotting it, whatever approvals you want to take, everything end to end, you take care. Towards the end, you give me 75%, 25% you take. So if somebody comes for booking at that point of time, you take that 25%, you give me balance the 75%. That means the developer is incurring the cost of development, sanctioning cost, everything he incurs. So at the time of transfer, when he finds a buyer, what kind of arrangement is going to happen is that he will be, the landowner will be, the title will rest with the landowner only. See, title will not get transferred to the JDA. Through JDA, it will not be transferred. So the landowner will hold the title. He will come in the form of, he's a technical person. So he will come and do all the advisory and other stuff. Once he finds through his advertisement, if he finds a buyer, he will be collecting the money. Let us put it in some escrow account, common account. So once that money comes into that, of course, through RERA also will kick in. Once it comes into the designated account, portion of me relating to 75% will come to me, 25% he will take it. So this is profit sharing. Next is that revenue sharing. When it comes to the revenue sharing, we both of us will enter into an agreement, just like earlier what I said. Out of that, he will be taking 25%, not in the form of cash, in the form of land. Whether the demarked land is he taking or how he takes, that's all purely contractual terms. So he will be taking 25% of it. I will be taking 75%. Once I can find my own buyer, he can find his own buyer. So what he will be rendering to me is he rendering construction service or does he render works contract? That is the, something which we have to deliberate upon. I will take you through in the next slides. So first, when it comes to profit sharing with respect to JDA, here in this profit sharing, the landowner gives the permission. Does he transfer his land? No, he does not transfer any development. Does he transfer the development right when he allows him to come and do the development? It is not development as we see in apartments, because once that land is given to the developer in the normal construction services, in the normal apartments where I handled in the previous sessions, I handled about 1 hour of session only on development rights. So here in this case, in case of plotted development, the landowner does not transfer any kind of development rights to the developer. He gives only the permission to enter and then do the leveling. That's all. There is nothing beyond that. So another way of looking at it is that without you give some permission, he can't even come and do the development. So for the argument, for the sake of understanding, let us understand both ways. The landowner gives the right to develop. Develop, what I mean is only the leveling of land, fencing it, drilling and making some chamber inside, putting the water connection, drainage, sewage, respect to that land, particular land, over and above what is guided by the law. Over and above that, for that particular land, if he does something, then unless and until I give some right to do that, he will not be able to enter. So for a minute, let us assume that he is coming here and I am giving my development right to the developer. Then what service does he do after entering? He does all the whatever, the leveling of land, all that. That is the service that he does. Once after that, in the profit sharing, developer takes control of that land, controls of the selling of the project, and then he finds a buyer, collects the money in the escrow designated account, gives it to the landowner. As far as landowner is concerned, no investment for him. What he gets is 75% of the cash because of holding the land at a later point of time. As and when the developer calls, he will go for signing and then sign the release deed, whatever, the agreement, sale deed, and come out. That's the only thing. As far as the developer is concerned, he is investing his money, time, everything for developing the land. The profit for him out of this project is the 25% on the sale value. Depending on the market, depending on the demand, he will be pricing it. So it's done over a period of time. If no lands are sold on that, nothing is getting sold, then he will be at the loss. That is what the understanding of profit sharing. In my view, that is what the understanding. So in that case, what happens? When can he collect tax from the seller, end consumer? The answer can be different because there are various, there are 1 or 2 AARs which have interpreted in a different way. So we will come to that later point of time. For the time being, let us understand that there is a tax element. Who has to pay, when he has to pay, that we will discuss later. So the next part is the revenue sharing. When it comes to revenue share, when it comes to area sharing, the concept is the same, just like how we dealt for apartments. It's more or less the same. Only difference is that at the discretion of the developer, in joint discussion with the landowner, properly drafting with the RERA authorities, if possible, there can be a view that you can have 2 different agreements. One is for construction, one is for the land, just to minimize the taxes, or it can use it as a tax planning mechanism. So that is also debatable. There is nothing like this is the correct way to do. The reason why I am giving 2 different views is because of the the advanced rulings and other stuff which has come, I will tell you where it, so we will understand that and then come back here. So when I talk about revenue sharing, when I talk about revenue sharing, I am taking up a real live case where this was, the application was filed for clarification before the advanced ruling authority and appellate advanced ruling authority. Both have held, uphold the appellate authority, uphold the decision of advanced ruling authority. So now let us understand what is the ratio, what is the questions that were put forward before the authority, what is the view of the department, what is the view of the department. This is sometime in 2019. So I will just take you backward about 2 years, fast forward. Now, if I have to come here in 2024, we are sitting. If I open the trump card, then everything will get closed. So let me just hold on. This is the 2019 scenario. I am taking this to understand for all of you to understand how the issue on plotted development is getting crystallized. The issues are getting, resolved, how it is getting simplified. With that intention only, I am sharing this. So now 2019, when we go back in time, this is the advance ruling. The landowner enters into JDA with the applicant. So the cost of development, these are all the facts which we all know. This is nothing but the revenue sharing model. The question before the authorities were whether activity of development and sale of land attract GST. If you look at this contract here, it is something very specific in the sense the landowner enters into JDA with the developer. The developer takes the power of attorney or control over the land. At the time of selling, he only collects the money. That is, the developer only collects the money and then gives it to the landowner. As far as the contract is concerned, just because he enters into a JDA, which is a non-revocable, the position taken by the developer is that he becomes the owner of the land and he only transfers. So the questions before the authority is that since I am developing the land and I am selling it, am I liable for GST? Do I need to collect GST from my buyers? Okay, this is the question. So the authorities held that you no longer hold the land. The land still rests with the developer, with the landowner only. You are only facilitating the transaction. So you are liable for GST to the extent of your whatever share. 25% is your share. So you have to pay GST at 25%. As far as the landowner is concerned, that's a different question. Since he is selling the land, then if he's selling the mere land, then as per entry schedule 3, entry 5, there is no GST. If he is adding, say, development, and he sometimes, there are few builders who give great amenities, luxurious amenities in the sense park, school, everything is built. It will be like, say, Adarsh Farm Meadow, something like that if you have. So there you cannot call it as a mere plotted development. There is something more beyond. That means he has intention to carry on further development in future. If that being the case, then at the time of development, you are already loading the cost of development and infrastructure and amenities onto the land and giving the option that within so and so time, the purchaser, that is the buyer of the land, will have to come back for future development only to him. Since those conditions are attached, the authority held that it cannot be called as a mere sale of land. There is something beyond. It cannot be held that you are selling a composite supply or principal supply, where my land is my principal supply. So whatever development charges I am adding, since that being the exempted supply, this is also exempted. So it goes out of GST, cannot be argued, because please remember, it will not fall into the composite supply at all, because the land itself is outside GST. That means it's neither supply of goods nor supply of services. It means that you cannot say that it is a composite supply. It just falls apart from the definition of composite supply itself. When you are developing something which is not the main supply itself is not a supply, and you are saying that the development charges are attached to the principal supply, so it will become a composite supply. No, your understanding is wrong. The sale of land is outside this. So development charges are liable for tax. You are supposed to pay tax. Who means the developer has to pay on the development charges. Mere sale of land only is not taxable. You cannot say that all the services are bundled. The bundling concept will not work. This is what my understanding. Probably I have added here and there because I have read other things also, but this is the basic understanding or the thought process in the department. This is the view of department when it comes to plotted development. They want to bring out this fact because many of the developers, I mean, this is just out of context. Some of the developers, what they do, they do the land value high and show some portion of it as a development charges so that they can minimize the taxes. But government also very clear, the GST department also very clear, when you are bundling it, you pay on the 18% or whatever it is, whether it is 18% or it is 5%, that's also the question of debate. They are saying that GST will be applicable even if it is bundled. So that was the position in 2019. So 2019, 20, 21, 20, up to 2021, there were a lot of issues, whether what happens to the development right, what would be the sale of land, is it taxable, can I bifurcate the agreement? If I do it, development charges also loaded onto the land value, will GST be applicable on the entire value, or should I take 1/3 after the 1st of April 2019 notification, 3/2019 notification, can I take for plotted development? So many questions, so many disputes were going on. So, but next, if you see, when it comes to Prahita constructions, this is Telangana High Court. This is also not very relevant, where it was held that 246A was brought in. They said that the court held that on development, on the development right, GST is very much applicable. So don't say that it is a land and sale of land. So it's an inferior right. It was very clearly held that development charges are liable for GST. So that let us just park it here, because the questions asked in this was development charges are liable for taxation. The facts, if I have to tell you, it is little bit complex because he is also calling it as a registered person. Other person is also registered to registered. So,
Madam, it's all getting confusing. If it is not relevant, it is not relevant.
we'll leave it. We'll leave
because
it. Yes, sir. We will leave it.
Starting it is confusing, and already we are enough confused. And also, development rights, development charges are totally different terms. Let us not use it as if it is interchangeable or near cousins.
Yes, sir. Development charges are completely different. Development charges are above the surface of the land, whatever you are doing.
The two terms are totally different. Let us not use development rights and development charges as interchangeable, or one is the consideration for the other. They are not near cousins also. They are totally unrelated expressions. If all these confusions are there, we will leave the confusion part of it. If you start discussing the confusion, then what are we going to do? You should suffer the confusion and give us the clarity.
So this is Munjal by Manish Bhatt Union versus Union of India. This also AAR. Then they went to Gujarat High Court. This is something very different because the petitioner is the person who's defending the case. Like, he is the person who's taking it to the advance ruling authority and going to the court. So the facts of the case is that the petitioner enters into an agreement with the developer for purchase of land, and two distinct considerations were agreed upon. One is for sale of land, other one is for the construction of bungalow. The applicant, that means the applicant is very knowledgeable, so he knows in and out about GST. So when he looks into the agreement and the invoice, he sees that in the construction, at the time of giving the invoice, the builder had charged GST. So he says that he asked, on what basis have you done? The developer, that means the respondent in that case, he says that I relied upon notification number 11, where it says that 1/3 deduction can be claimed for the land, and on the balance, I have charged GST at 18%, of course, 1/3 of 18, whatever it is. So the question before the authorities for the petitioner is that when there are two distinguishable identifiable contract, one is for sale of land, other one is for sale of a construction contract, why should those two be merged? What is the necessity? This was the question before the authority. So the applicant argued that this is the argument also. I'm not going in detail. One thing which I want to highlight upon here is that in the L&T decision, these are all prior to GST. So this aspect theory, dominant intention theory, these are all I have described at the end. I don't want to go into detail of that. So as per the aspect theory, you have to see which aspect. There can be encroachment, there can be overlapping from two acts. One is from the state, one is from the central, or one is from GST, other is one from land and as per Stamp Act or Registration Act. But one statute has already taxed on certain portion of the value of some tax has been charged on some value, some aspect. The same aspect cannot be charged by a different statute on the same value. So this was the contention. Then in the L&T decision, they have said that there cannot be anything. You have to see whichever act has already charged, that needs to be excluded. So he's bringing into this concept saying, when I have two different agreements, one is for works contract, one is for the other land, why both should be combined and 1/3 should be deducted. So these are the arguments which are placed before the authorities. And he also, Gannon Dunkerley case, which is dominant intention theory, also he brought in. The dominant intention, as per that theory, the buyer buys only the land. So the dominant intention of the buyer should be looked into. The intention of the contract in the plotted development is only sale of land. He is not interested what kind of development that the landowner or developer has carried on or carried out in the land area. He has come to the buyer, he has come to the landowner and entering into a contract only for the limited purpose of buying the plot, whether if it is developed. If it is already developed, it's okay. He's not interested in that. So if that being the case, the main intention is only land, not beyond. So it cannot be said that just because some development charges are added, the contract, the GST will be applicable on that. It is only the dominant intention is only to sell the land. So there is no GST. So that was his contention. Whereas,
Madam, let me pause you.
Yes, sir.
What is your answer to this argument? Because if we start hearing arguments, we'll forget what the ruling was. What is your position to what argument has been advanced? Argument advanced, like you say, as you have said, is the buyer does not care about any development. He is only interested in the plot. What is your view about it? Is that what the buyer's intention is? Or is the buyer's intention downplayed to somehow convince the court that this is a transfer of land simpliciter?
If the buyer is buying only the land with the intention...
They have argued that the whole idea is to buy the land, development, etc. is not relevant, and they produced this dominant intention argument. What is your view? Is it true? Because you are a knowledgeable chartered accountant, you are a knowledgeable consumer, you are aware of the things in the market. What is your view? Is the buyer agnostic, indifferent to the development activity? and focusing only on the 30-40 site, or he wants both equally. He wants the 30-40 site, but he also wants the clubhouse. He also wants the very wide roads, all those beautiful things that they do. What is your idea? What is your view?
My,
Not
my
your view. What is your personal view?
my personal view would be, in the case of plotted development, it is, I'm not buying only the barren land. Of course, there is some development activities carried on. It is not a mere land. It is not.
That's all.
mere land.
So therefore, let us not. I mean, all of us are like that. Everybody is like that only. I buy a Soba developers the plot because of the brand name, because of the quality assurance I get on the title, because of the amenities, etc., etc. I buy all of those things, and the way to enjoy all of those things is by buying a plot. It is like somebody was saying, the prosecution knows who committed the murder. The defense knows who committed the murder. The judge is only on trial. How the judge will come out with decision, that's all. Tomorrow, if he gets acquitted on appeal, then the judge's decision was wrong. So if we start deliberating on the argument someone is trying to say, although you are convinced, I am convinced, everybody, all the 14 people who are participating are convinced it is not only a plan. So therefore, we should run through these arguments if you really want. Actually, avoid all the arguments and get to the conclusion, because as if it should not be that you're trying, you believe that it is only land. So it is both that are important. So now we proceed on the basis of a factual understanding and not a fictional argument that was advanced.
So this was the scenario till 2019, sir, 22. But if you look at the circular number 177, which was issued subsequent to that circular is giving the best benefit. It's in 2022, which says that if you look at point 14.4, it may be noted that any service provided for development of land like leveling, laying of drainage lines shall attract GST at applicable rate for such services. So
no, but one minute. See, this circular also, it is speaking from the point of view of the contractor, or it is speaking from the point of view of the developer, or from the point of view of the landowner vis-a-vis the buyer. See, we have to see, it's like whatever the heart wants to, whatever the mind wants to know, the eyes are reading. We'll come to this circular because we were at MM Bhatt's judgment. We have not even come here. We'll address those issues.
डबल जगह में पूरा ग्राउंड में
Mute mado.
So, as far as this judgment is concerned, sir, here the facts are different. Here he says 2 agreement. So when there are 2 agreements, whether sir, my view, I tell you, sir.
That's the other point. Please.
As far as my view is concerned, I beg to differ from this judgment because number 1, it has not addressed many of the points. Even I have my own doubts after reading this judgment. Number 1 is that at the time of entering itself, you know that you are going to buy a bungalow. So when you are separating it out, land separate, building separate, you know that in 2022, RERA is also applicable. You cannot have 2 agreements. How did he have 2 agreements? And when you are combining it, 1/3 definitely, because that is a valuation mechanism which is given. But once when you are merging these 2 agreements are not separable, not severable. So it is one combined merged agreement only can be taken. If you take that position, GST is very much applicable. It is just not mere sale of land. Only on the combined value, GST would be applicable as per the valuation provisions. Whether that notification 3 is applicable or not, those are all different story. Those are all debatable. I'm not getting into that. But to my simple understanding, GST is applicable.
So therefore, we will delete these slides about MM Bhatt. Otherwise, this PowerPoint will become a treatise on GST, where we are doing a survey of all the development of law. We'll move on to, we'll take the conclusion and then we'll move. In MM, but the conclusion was you don't have to follow 1/3, but nobody in the country is following MM, but we move on.
So after
Because you
this,
have not even come to the main meat of the matter. The main issue in this today's morning, already 9 o'clock. You have not come there only.
yes, sir. Sir, it's it's over, sir. This is where I am coming from. So because the main crux of discussion today is only this. Only these 2 points with respect to plotted development. When it comes to when a landowner enters into JDA with the developer, what are the GST applicability? What is the input tax credit applicability? That's all. Whether there is a supply, what is the time of supply, what is the valuation? This is what we have to discuss. So after that circular, I am drawn more from the circular because I'm sticking on to what is there. Forget about all the judgment. Those are all only for our understanding only and for academic interest. If some clients come to me, what do I do? Is that what I have to, explain it now? When I want to put it in a simple words, in case of profit sharing agreement, the first is that landowner transfers development right. Does he transfer development right? The answer is no. He does not transfer any development right to the developer. The land title rests with him only. So GST is not applicable. So when GST is not applicable, there is no question of RCM. There is no question of when there is no supply, all the other things fail. So this is one.
No. See, when you say profit sharing, who is doing the business? The landowner is doing the business.
Developer is doing the business, sir.
Now, developer, what hold he is having on the land? After spending 100 crores, landowner will terminate the agreement and tell the developer to get out. Please describe what is this business model of profit sharing?
So,
what is the profit? Because you have to keep in mind that if the developer is investing 100 crores in this barren land, but the title is still with the landowner, who is transferring to the buyer? Landowner is transferring to the buyer. Then what is profit sharing here? Last reimbursement, developer is incurring 100 crores. That is not at all the business model. What is this? Profit sharing is different from revenue sharing, as you described earlier. Revenue sharing is from the top line, they will get some ratio. Profit sharing is from bottom line, they will get some share. If from the bottom line they are getting, then is it a partnership firm? Is it a partnership firm? If it is a partnership firm, then only they will share the profit. When you're saying if it is not a partnership firm and profit is being shared, then who collects the total income? You tell me, gross revenue will go in whose hands? Developer's hands or landowner's hands?
It will come to the common account.
It must be under somebody's PAN number, no, madam?
20, yes, sir.
No, whose account they will get the money
the
first?
Landowner. It will go to the
okay. Now, all the 100% of the revenue will come to the landowner. And the landowner has to pay the developer. Now, when he makes payment to the developer, is it a expenditure or a distribution of after-tax income?
A distribution of after-tax income.
Yeah, where you are going. Now, they are paying income tax on turnover basically. Landowner has no expenditure. All the expenditure 100 crores is in developer's books.
Correct.
First on turnover, they will pay 30% tax. Remaining 70% they will distribute to. No. Profit sharing business model itself will not be viable like this. We are calling it profit sharing. It is actually an expenditure above the line. And then there is going to be TDS. If TDS also is there and it is expenditure above the line, it is attracting GST. So therefore, in a plot development project, you delete the profit sharing business model. Don't discuss that model because that model does not exist because it is not viable. We will take only joint development, area sharing or revenue sharing.
Okay, so.
Next.
So, okay, so I will not discuss about this profit sharing model. Let us
Hmm.
discuss about the revenue sharing model. Revenue sharing, in this revenue sharing model, what happens? Whatever the customer pays on the upfront, immediately will it get split into the landowner and the developer?
Everything will come to developer's bank account.
Hmm.
Developer will take that money and he will share it with the landowner, whatever is the commercially agreed.
Correct.
It is not sharing of any, it is an expenditure.
Correct.
It is not splitting at the source. It is not diversion of income by overriding charge. It is an
So-
expenditure. So we'll identify what the name is revenue sharing, but it is a contractual payment liable for TDS and GST.
So if that being the case, the landowner will be handing over the development rights to the developer. The entire land.
Correct.
So when then there would be the component of, development rights would also get taxed. Development right will get taxed. And in turn, there will be four legs to the transaction. One is that the landowner surrenders his development rights to the developer. Developer does some service. You can call it as a construction service. Just like we have already, earlier we have already discussed on this.
Correct.
So that's the reason why I did not go deep into that, because
Go on.
so the developer will be undertaking some construction to the extent of whatever the profit sharing, revenue sharing, what you call it, 25% or whatever. To that extent, he will be liable for, to that extent of say 25% of profit share, revenue sharing, he will be liable to tax GST on the construction services to the landowner.
No.
Whether
No. See, the developer does not provide any construction service to the landowner in a revenue sharing JDA. The
Sir,
landowner, madam, you are the landowner.
correct.
You will give me development rights. I will give you cash. You are not interested in construction service, this site, that site, nothing you are interested in. You will give development rights to me. You want cash. That's the end of the revenue sharing JDA. All the sites I develop, as a developer, I will go and sell in the market. Whether I sell, whether I don't sell, all these things is my problem. As far as you are concerned, you will give me development rights, you will take money. Because you don't want to take fixed amount of money, you want to take variable amount of money depending on how the finished product comes out and what market it commands in the market, what price it commands in the market.
So whatever I'm receiving that consideration, that would be taxable in my hands. That means I am the landowner.
No, when you receive money,
I will be, yes,
you are a supplier.
I am receiving money. What I'm
So
saying, development right, in turn I'm getting the cash.
You are supplying development rights. You are supplying development rights. You are getting cash.
Correct.
The entire discussion today is about whether this is liable to tax. The answer to the answer to this is dependent on what does the developer do on the 100% of the plot that he is developing when he is selling. So this first question, supply of development, Annapurna madam idaralla or irbeku madam idare. Okay. See, the development rights that the landowner gives to the developer, what is the treatment to be given there is a directly contingent upon what stand the developer will take when he is selling the developed plots. So the first part of your question, we will put a pause. We will go to the next part of the question, which you can please explain. When I come to you, you are the developer. I will come to you as a customer. Madam, I want to buy one 30-40 site. How much is the cost? Neighboring site, they are charging 1,000 rupees. You are charging 10,000 rupees. Please tell me. These are the discussions we are going to have. Now you please tell me what is the tax treatment? As a developer, you will collect from me for this 10,000 rupees per square feet.
So 10,000 rupees per square feet is at what I'm collecting against the neighboring plots of say around 5,000 when it is going at 5,000. Market rate is 5,000, whereas I'm collecting 10,000.
Don't worry about me. I'm only saying you are giving me 30-40 site
Hmm.
and you're charging me 10,000 rupees per square feet. Now you tell me what GST. Others are selling more, others are selling less. It doesn't matter.
So it is a plotted development. It's a plotted development. And as a developer, what would be the tax implication? How much of tax does the developer needs to tax on from the customer? That's what.
Customer. As a customer, I am arguing everything that you argued earlier. I am dominant intention theory, lot to losk, everything I will say. To tell you, plot is a plot, land is a land, this is, that is not this. Ultimately, you are providing only land, beginning also land, end also land, big land, small land, all that story I will tell you. I don't want to pay any GST. I will now quote all circulars. I will quote all advanced rulings. As a developer, what are you going to do?
So, I will be taking the stance from notification 3. I will say that 1/3 will be the, towards the land, towards the valuation, 1/3 will go out for land. On the balance amount, on the total consideration, as far as the buyer is concerned, 5% GST I would be charging, whether it is a land or a building or whatever it is. I'm selling the completed product or semi-finished, only the developed land, whatever it may be, to the customer.
So now you are going totally against advance ruling. You are going totally against circular.
Correct. I'm going against the circular.
No, so then, no, that we cannot readily agree. Now we will need a few participants to come on board and argue against what Sujata madam is saying. Who will do this? Annapurna madam, you are the final arbitrator. Deepak Kothari. ಏನಪ್ಪ ಎಲ್ಲ ನೀರು ತುಂಬಿಸ್ತಾ ಇದೆಯಾ ಅಂತ ಹೋಟೆಲ್ ತಿಂದಿಯಾ?
Sir, only 1 minute, just 1 second, sir. If I go by the circular and this notification, GST is not applicable at all, sir, for plotted development, but I cannot conclude it that way.
No. So once you have taken one stand, you go vote for Rahul Gandhi or Modi.
I will, yes, sir.
Deepak. Illo idea? Illo. Who else will comment? Anybody? Now suddenly full radio silence. ಎಲ್ಲ ಲಾಗಿನ್ ಮಾಡಿ ಮನೆಗೆ ಹೋಗಿ ಟಿಫಿನ್ ಮಾಡಕ್ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲರೂ. ಓಕೆ, ಯಾರು ಇಲ್ಲ. ಅನ್ನಪೂರ್ಣ ಮೇಡಮ್, ನೀವೇ ಬರ್ಬೇಕು.
Yes, sir. I think before going into this, I think we all are aware that there are different school of thoughts on these issues, whether it plot falls within the definition of 3/19, 4/19, that is a different aspect. But discussing for the rate of tax, as Sujata madam is saying that it should be 5% with 1/3 deduction of land, I still don't agree with that, sir, because it's not something which we are looking as a construction services. We are looking it as a it's not a construction of an apartment. It is just as a development agreement, development charges which has been incurred in the case of revenue model to the extent of whatever the development he has done. And according to me, it may not be a pure color of construction. It is it is kind of a contractor to a landowner where he is providing that services. And accordingly, I think it should be at 18% that residual entry in 3/19 and not that 1, 2, 3, 4, whatever is there for that RREP, all that.
Understood. Madam, now my question is,
Yeah.
I am coming here to buy 30-40 site. I am paying, builder is charging, quoting 10,000 rupees. Now you tell me on what I will charge it. I should pay 18%.
See, it's only plotted, na, sir. It's only for the plotted as a developer.
Square feet, he's offering 10,000, very premium, very high Shah Rukh Khan, everybody is staying there. 10,000 rupees, something he's marketing he's done. 10,000
Yeah.
rupees per square feet, I have no problem. 18%
sir.
which you said has to be paid, it has to be paid on what?
Sir, the appreciation, whatever is happening, that cost can be marked up to the extent of land cost and as well as to the development cost, na, sir. Because I
No,
cannot say that appreciation is only towards the land.
no, I am coming as a buyer. I want to only
Yes.
negotiate the rate per square feet, 10,000. Okay, 30, 40, this corner site I have decided, selected. Now you are quoting me 10,000 rupees. I say, okay, 10,000 is fine. On what I have to pay GST, you should only, you are the developer, you should only tell me whether you will say on 10,000 I have to pay 18%, or
No,
on
sir.
1,000 rupees you are saying I have to pay 18%, or you will say I don't have to pay any GST.
If it is a 10,000 rupees as a developer, sir, not like as a customer might be looking into different thing, but as a developer, I have to segregate my land price and development price so that accordingly I can collect the GST only to the extent of development price.
So therefore you will tell me that
Mm.
okay, 9,000 I will not charge any GST. On 1,000 I will charge GST at 18%. Let's say, just for the simplicity of calculation, we will take it as 1,000 and 1,000. Now, my question is, there are, I have come to purchase this plot after completion of the project.
Okay.
After you have got OC, after everything you have done.
Mm.
So I am telling you, madam, when I am buying a villa, when I am buying a apartment from Shobha developers only, after
Mm.
OC, there is no GST.
Mm.
For you are charging 18% on 1,000 rupees after project is complete. After project is complete means no GST on anything. That is what my consultant is telling. Please tell.
So that schedule 2 and 5th entry, whatever is there for that construction survey.
Project is over.
Yeah. So project is over. You have already got the release order, right?
When associations are formed, some people are already started to do their own constructing their own.
House.
As per their choice, they started to construct also ugly houses in this colony.
Mm.
I am by 30-40 site. Now you are
Mm.
saying you are going to split the car and the engine and you are charging that 1,000 rupees, 18% GST. I am saying why you are doing, madam?
Sir, I still call myself as a contractor for that land, sir. I
But
don't
my
call it.
agreement, madam, my agreement does not say you can change the name that you give to yourself. My agreement says you are in your agreement itself, the format which you have given. Hello, one name. Now your agreement says you are, whereas you have undertaken a project like this, whereas you have done this, whereas you have got all the approvals, whereas you have got the final completion. As per Schedule A, it is a larger land. Schedule B is the identified property, north by so and so, south, east, west. And the total 1,200 square feet is offered for sale of 10,000 rupees. And so is the buyer who is willing to buy and agree to enter into this agreement. Now, when the agreement is called like this, how can you call yourself contractor?
Correct. And in many cases, even the release order is given, like even if it is completed only 30%.
See, when we do all this release order business, it will add
Correct.
more variables and sort of pollute the mind. When we look
Correct.
at a simple agreement.
But sir, for this plotted development, I still believe that we don't have the concept of that completion certificate, what we have for apartment. Though
No,
there is a
you're
no,
right.
why
You're right. I'm only saying you have to take some document
yes.
that says nothing further remains to be done. Whatever needs to be done has been done. In such a factual scenario, what is it that you are trying to sell to me? Because there's no need now for us to go into complex factual information. Project
Okay.
was commenced on so and so date. It is not. ಅದೆಲ್ಲ ಬೇಡ. In this, on the north side corner, one site is there. Please pay tax on that. Please tell me what is. That's the question.
Sir, can we, that is one way of looking into that, sir, just with your view. Can we take it as, because in few of the instances we have seen that they have taken as a total, whatever the cost you have incurred and booked for those that development of plots. And then they have marked up with that plus 10% or whatever it is. And then it has been divided between the areas of the plot, and accordingly the cost development price has been arrived. So that is a one way which.
Madam, my concern is
Hmm.
why are we going into cost of manufacture of a product to decide the classification of the finished product? To make a car, I use plastic items, rubber items, iron items, copper items. But we are trying to confuse the factual pattern by going into a lot of costing, MAFA, SFM, IT, QT, everything we are doing. The short question is, in that north corner, there is one site. How much is it for me? That's all.
Yeah.
Is the question.
Yeah, so 10,000, as you said, 10,000 per square feet, we have quoted to our customer. Now the issue is how to break up for computing the taxes, right, sir?
Now,
Because
now we have to, correct.
Yeah. Because this 2A, whatever has been given in this 3/19 and 4/4.
Better. Don't go there. Don't go there. See, Sujata madam is under agent 2A.
Yeah,
You are under
that's all. Yeah.
entry number
I'm on
3,
that
Roman
detail.
number 12, 18%.
Yes, sir.
You hear it.
So I still believe, sir, it should be at 18%. That 2A is not applicable to me.
18 on what? 18 on 1,000 is not correct. Because 18 on 10,000 cannot be the case.
Yes, sir.
18 on 1,000, because as a buyer, to me, 1,000 is a meaningless word expression. Something you have magically come up with it in your mind as to what may be your cost of doing the development works. We all know what is composite supply. When I buy a car, I will not pay separately for the tire.
Yes.
Your tire also is costed you something. Engine also costed you something. I want car. Because we don't have to complicate the question to come out with to make the answer look clever. I want plot. 10,000 you quoted. Over. See, it may cost you 12,000 also. Sometimes surf is costing more than the selling price. Why they sell surf at a loss? Because that's their management decision. Why they want to do like that? So the short question is, when we are selling 10,000 rupees, where is the occasion to subdivide the single price negotiated into various cost components and then try to tax it? In GST, it is there in two places. One is what Sujata madam told. Another is in that ICU bed, where they are saying you have to pay GST on the. Then the other one is that solar. In a plot sale, where is the necessity to reverse engineer the 10,000 rupees and arrive at 9 plus 1?
Yes, sir. I agree with you.
So now, therefore, if everything is complete, because my fear is when we pay more tax, nobody will object from the department side. Now, madam, we will stick to the same example. Sujata madam, you are also there.
No. Sir, now I'm getting an answer from Annapurna that on 10,000 rupees, 18% GST, she will be late.
No. Also changed the party. Now she has joined another party. You are saying 5% on 10,000. Annapurna madam is now saying 0% on 10,000.
So she's going by the circular.
She is saying 0%. Schedule 3, not circular.
Sale of land.
Sale of
Okay.
land, though he does
Okay.
not own the land.
ஐயோ கடவுளே நீங்க இருங்க நீங்க அப்படியே
Okay,
இருங்க
sir. Okay, sir. Annapurna is, Kabra is telling that it is 0%. GST is
0%.
not liable.
Now,
Yes, sir.
Annapurna madam, third question for you. This is a revenue sharing, not a area sharing, between the developer and the end consumer, the buyer of the site. It is 0% tax. We'll take a hypothetical example. No sales are made before completing the development. Entire development has been financed by the developer. Entire development has been financed by the developer. On the date of getting full release, of all the developed plots, the JDA was 1 year ago. Full release was obtained 1 year later. So 1st April, JDA entered into, 31st March next year, entire thing is developed and completed. As a customer, I have come to purchase in the month of April after development, 10,000 rupees, you have quoted 0% GST. My question is, on the development rights given by the landowner to the developer, what is the GST? This is now not about plot gate, nothing. So circular will not apply, Godrej will not apply, Rubia Khanum will not apply. On the development rights,
all that is for the own land. Now we are coming into the revenue sharing and area sharing. Yeah.
Now in
Yes.
revenue sharing JDA, development rights has been given by the landowner to the developer. That is not in dispute.
Yes, sir.
Taking the development rights, the developer has completed the development and started to offer units for sale after self-financing the development.
Yes, sir.
Now, what is the tax treatment inter developer and landowner?
In case of revenue sharing, sir, right?
Yes, 100 crores I am giving the landowner.
Okay. So it is purely revenue sharing, sir.
Purely revenue sharing.
So basically, because there is a transfer of right which has been done by the landowner to a developer, against that, he is going to pay a consideration to a landowner, either it will be in the form of monetary consideration because it is
100 crores. 100 crores.
Yeah. So being a revenue share, it will be paid in monetary consideration. And what he is going to do is, whenever he is going to collect from the customer, he is going to appropriate a specific part to a landowner and a specific appropriation to a developer. So
400 crores. I'm selling this for 300 crores totally.
Okay.
I will take 300 crores from all the buyers and I will take 100, keep 200 and I will pay 100 to the landowner. And as we discussed in the earlier part, this 100 that I'm going to pay is an expenditure in my P&L. It is not a share of profit to a partner exempt from income tax. It is not even that I will only account 200 as my income, even though I'm collecting 300. I will collect 300, show 100 as my expenditure.
100 as expenditure. So
as
2:1, sir. This ratio will be 2:1. Okay.
You're right.
It's not a profit sharing, sir. It's a revenue sharing because
Revenue
it's a purely revenue sharing. So it is what extent I am trying to understand, sir. For out of the 100 will be 100 is pertaining to a developer and 200 is pertaining to a landowner. Just for an example.
100 is to the landowner.
100 is to the landowner and 200 is to the extent of developer. So what I am trying to understand is, in the case of revenue sharing, to the extent of the developer share, he has to collect the 18% GST on that 200 whatever amount we are talking, sir. Because when it is appropriated towards land, it has gone to a landowner to the extent of land. To the extent of development, it has been retained by the developer. So can we look?
Now, what happened? In the previous part, you have explained that on that 10,000 rupees, no GST, which means on the entire 300 crores that the developer collects, no GST.
Yeah, I'm selling it as a plain land. I'm selling it as a land.
30, 40, 30, 40, 60, 40, 50, 80, all that has been done.
Yes, yes, yes.
So, no GST has been collected on the entire 300 crores.
Hmm, hmm,
200 crores which I am paying to the landowner, what GST has to be done there?
Because what I am trying to understand here is this transfer of rights. What we are trying to study here is because based on our understanding whether it is area sharing or revenue sharing, there is some right which has been transferred from the landowner to developer to develop on plot.
You're
So
right.
to that extent, yes, sir. So to that extent, there should be an implication of tax, no, sir.
Sir,
So,
RCM
you're
making.
ಏನಪ್ಪ ಯಾರೋ ಅದಲ್ಲಿ ಬಟನ್ ಪ್ರೆಸ್ ಆಗ್ತದೆ. So you are saying that on this 100 crores, some GST is payable.
Yes, sir.
Are you saying that on this 100 crore payment made to the landowner, GST is payable?
Yes, sir. To the extent of rights which has been
What is the
transferred.
rate of tax?
Because 4/19 is also
No,
not
yeah.
applicable.
What is rate of tax? 18%.
Yes, sir.
18%.
Yes, sir.
No, FCM will come to. On this 100 crore, 18% GST is payable. On the
Yes.
300 crore, no output tax is payable. Therefore, there is no question of any ITC, GTC, nothing. In a plot development project, from our this morning's discussion, the conclusion is that development rights is liable to GST at 18% on the total revenue collected by the landowner from the developer.
Yes, sir. That is my
Correct.
understanding.
So, you see, now you are the right person to guide us on this. In the advance rulings that we have,
Hmm.
they have gone into answering question on 10,000 what should be GST,
Hmm.
whether it should be 9,000 plus 1,000 or 10,000 plus 0. All those questions have been answered.
Hmm.
The rulings have not answered the question of what about this 100 crores?
Hmm. Correct, sir.
Because you are out of 3/19,
Hmm.
because you are out of 3/19,
Hmm.
you don't have the exemption on these 100 crores.
Yes, sir.
Correct, no, madam?
Yes, sir.
You are under 312.
Yes.
Now, the decision not to pay GST on plot sold to buyer has a direct cost increase to the extent of 18% on 100 crores.
Yes.
18% on 100 crores is
Yeah.
9% on 200 crores.
Yes, sir.
So the builder who thought that it is 9% was tax free is actually paying 9% because this 18 landowner does not have money to pay.
Yes.
So he will pass on that 18 incidents to the landowner, to the developer.
Hmm.
You understand, madam?
So it will become like an input cost, like how he has for other things. So similarly, it will
Correct.
be like.
But today are they paying tax on development rights?
No, sir, they're not being
We,
so.
so we are claiming exemption on development rights and we are
Yes.
not paying tax on output side.
Yes, sir.
How do we do this? We are either under 3/19 or we are out of 3/19. We cannot be traveling in two boats.
Yes, sir.
Next, why are we paying tax on 500 or 1,000?
Hmm.
The reason why we are paying tax on something nominal
Hmm.
is to show that we have fit into 3/19 so that we can protect ourselves from RCM.
Yes, sir.
Then why is it 9,000 plus 1,000? There we are saying Manish Bhai, but saying that you don't have to follow 1/3. Now you
Yes.
see how the whole argument will crumble, because we are selectively using parts of different things. We are taking engine from car, we are taking
Yes.
tires from a bullock cart,
Yes,
and we
sir.
are trying to construct a vehicle.
Yes, sir.
So therefore, in this plot development, we have to take entirely one stand. Entirely we will pay no tax on the unit sales, and we will therefore pay tax on development rights. We will entirely pay tax on unit sales and claim exemption on development rights. We cannot do best of both worlds.
Yes, sir.
The last point is, in mark spaces, what the AAA finally said. Sujata madam, can you give us the
Yes, sir, yes.
final conclusion in the AAA of mark spaces?
They say that to the extent of 25%, that means the profit sharing, revenue sharing, the
Hey,
developer
profit
has to
sharing not
pay.
scalable. See
The-
what they are saying there is, when you got the development rights from the landowner, you got the development rights from the landowner. How much did you make from that development rights? You got development rights. How much did you make? You made
10,000 rupees per square feet.
therefore pay 18% on the 10,000 they told in mark spaces. So therefore, mark spaces is not a good decision.
Yes, sir.
Mark spaces is not a good decision because they have made two transactions. The inward supply to the developer valued at the outward supply by the developer.
Yes.
That is why it is. So therefore,
Actually, we would have gone to High Court, sir, this mark space. They did not go.
mark spaces ultimately will go to the, so somewhere we are telling all bad disadvantageous advance rulings, everybody will go to High Court, get a stay order. Or everybody will alter the facts while implementing the transaction. Nobody will implement it exactly same way in which it was originally done.
Even
Now the
this
last,
Munjal, sir, this I think they got stayed, na, sir, from Supreme Court. Munjal Gujarat High Court decision. I
yeah,
was not. They got stayed, na, sir.
so what I'm saying is, what we have to consider, arguments in advance ruling or in court should not be cited as reliable authorities.
Yes, sir.
Arguments.
Sir, then what about this, sir? I asked my friend who's full-time into, real estate sector and
So,
he's
madam.
GST, sir. So the ground reality is they are not paying any taxes on plotted development, not on
No.
development rate and on the sale of land also.
Madam, now I tell you what. So first of all, we need to conclude. There are
Yes, sir.
participants who are
Yes, sir.
having
Yes, sir.
views.
Sir, your final view on, this plotted development, we will, take.
The final views are what both of you have given. What Annapurna madam said is, on 10,000 don't pay tax, but pay 18% tax on development rates.
Okay.
What you said is, pay 5% tax on unit sales, claim exemption on development rates. There is a in-between view that split this 10,000 into 9,000 plus 1,000. Split this 9,000 into 10,000 into 9,000 and 1,000. Pay 18% on 1,000, so the department does not think that you're not paying any tax. Something is better than nothing. Pay on this. There is a some confusing language in a circular. There is a clear advance
With a clear advance ruling also that says you have to pay tax on development charges that is collected from a buyer if you are collecting it separately. Now we have to see where somebody does not pay any tax on anything. They have a very weak case on development rights. They have a very weak case on development rights. So when you are advising anybody as to what should be done in a plot project, there are two aspects to look at it. What is the GST on your inward supply you are ready to pay? What is the GST on outward supply you are willing to collect and remit? On the inward supply, since it is a cost, as you commenced the presentation, you said there is a total confusion in the landscape of GST for the last 8 years. People are continuing to capitalize on the so-called confusion so that if the confusion is not there, clarity will come. That is dangerous for them. So on the inward supply, they are not paying any GST. On the outward supply, they are paying some tax better than no tax. I know a lot of instances where the units are being sold at 105 or 118. They are selling it for 100 plus 5 or 100 plus 18 because the market can bear. They're collecting GST but not remitting GST. Not in the name of GST, because the price has to be all inclusive. The developer is completely indemnifying themselves commercially from any future demand of GST. They're collecting it, they're not remitting it. So therefore, as
Sir, would this not become unjust enrichment, sir?
no, if they collect it as GST, they're hit by 76, but they're not collecting it. They're selling it for 105. They're selling it for 10,500 is the plot price, or 10,000 or 5,900 is the rate of the plot. They have marked up the cost and offered it in the market, and they're so be very careful when you are talking to developers. Keep in mind that they are very wise in making a decision how to price their product. They're very wise. And when they have conversation with consultants, they will present it like they are totally innocent. This is like you understand how this is operating. The whole approach is presented in such a way so that the one who is supposed to give an answer is already convinced. There are three views going around. One is pay 0%, pay 18% on by splitting the selling value, or pay no tax without doing any splitting, or pay 5%. This is as far as the outward supply is concerned. But on the inward supply is where my concern is, because the tax on inward supply is what is going to come and bite tomorrow.
Sir, this few summons are going around for this plotted development in few of the cases where the department has tried to take a declaration from the taxpayer saying that on what basis you believe that there is no liability of taxes on this transfer of rights and transfer of plots which are being given to the landowner. Either it is a revenue sharing or area sharing, because summons are given to many of the taxpayers who are under different models. So
Correct.
what I'm trying to understand is like now after this Prahita, we tried, but anyway now Prahita is also got reversed, so it is like that cannot be applicability. So now what is happening around is they have started issuing DRC 1A with some estimated value, and we are just waiting for the SCN, sir, because that will help us to decide what is the department reading to understand what is the value of supply or what is the time of supply, to make us understand better, because they have just arrived at some amount of some 5 crores, 3 crores. They have just said that you are liable to pay on this amount. So I think that will be the better way to take it, na, sir, to forward to
See,
understand.
See,
Yeah.
there are two aspects to looking at this. One
Mm.
is, what is the answer? What is when we are advising
Mm.
compliance? What is
Mm.
the answer when we are advising litigation?
Mm.
We should not think that there is one correct answer which we are going to put forward to in a show cause notice as well as to a client.
Mm.
For litigation,
Mm.
the allegation in the notice only has to be put on trial.
Mm.
In the reply to a notice, we don't have to explain what is the correct value and whether what we have done is correct. In a reply to a notice, what department is saying, is it correct or not? That's all is the question.
Mm.
So
Mm.
therefore, please don't allow arguments taken as far as notice is concerned
Mm.
to be the correct interpretation of law.
Mm.
Now, like you rightly said, if sale of plot is not 5%,
Mm.
if it is not 5%, there are again two answers. 0% on 10,000 or 18% on 1,000.
Mm.
Whichever it is, development rights is not exempt.
Correct.
If you are 5%, then development rights is exempt.
Mm.
Now the question is, what does the client want to do?
Mm.
The client says, my market will not absorb 5% on 10,000. Okay.
Mm.
Client will say, my market will absorb 18% on 1,000.
Mm.
Client will do what the market will bear.
Mm.
But what the client needs to be alerted about,
Mm.
because this 500 rupees also is not a lot of money. This 180 rupees also is not a lot of money. When you're looking at a plot of 10,000 rupees, what is this 180 rupees? It is nothing, pocket
Correct.
change. But he needs to be told, what about 18% on 100 crores?
Mm.
Tomorrow, if you get an issue on that, what is the stand you are going to take?
Correct.
Dhanashree madam, does it long answer for that short question that you asked? Let's answer.
Yes, sir.
As students of this subject, we should not ourselves be confused about Godrej, Bhopal Smart City, or this Manish Bhai Bhatt, etc. We should not see, confusions will be there. I mean, the whole job of litigation is to create a confusion. Don't know which confusion, which judge is going to be convinced with. Litigation strategy is different. Advisory is different. In advisory, we have to answer tax on outward what we will pay, tax on inward what we will pay.
Sir,
Sir,
only one
from your
question, sir. Even if you pay on the development charges, you are saying 18% you pay on the development charges. What guarantee that the department will come back that you did not pay on the development charges? Development rights you are paying. What about because on the end customer on the 10,000 rupees per square feet, you are not collecting any tax, taking a stand that it's a composite supply, only sale of land. But will the department not come back to you even after you paying 18% on that 100 crore?
Okay, we will take one by one these questions. First case is, on 100 crores we have paid 18%.
Correct.
On 10,000 we have paid 0%. Department will come back. Department will come back and say what? If I have collected GST and not paid, they can question. If I have not collected and not paid, department has to find a split of 10,000 into 9 plus 1, 9.5 plus 0.5, something they have to arrive at, isn't it? Department cannot.
The implication in that case would be huge.
Department, no. Department cannot. They cannot create supply out of thin air. 10,000 is the sale of plot and it is covered by Schedule 3. Can they say on 10,000 they will charge 18%? Impossible.
Correct.
They cannot say 10,000, 18% on 10,000. Then they have to they have to compute demand on something less than 10,000. Where is the power in section 15 or in the rules to do vivisection of a price? For solar power, they needed amendment. For medical ICU bed, they needed amendment. Where is the provision in the rules or in the tariff notification itself? It is not there. So therefore, this case is a very weak case for the department to make. The next
Sir,
question is, next question,
sir,
what Annapurna madam mentioned, summons are being issued, valuation is being arrived at, summons are being issued, valuation is being arrived at to say this is the value of your development rights. Now, madam, you continue, madam. You're saying.
yeah, that's what I was saying. Yeah.
Now, if they are trying to tax development rights, it is directly connected to the decision taken by the client not to pay tax on development rights. Because the client said, on 10,000, I will not pay any tax. That is, on outward supply, I will not pay any tax. Inward supply also, I will not pay any tax. Correct, no?
Yes, sir.
Or on outward supply, he paid some nominal tax on development charges to the extent of ITC or cost plus 10%. And then saying, on development rights, I'm not going to pay tax. In those cases, they have to be very careful. The argument used in mark spaces can come and affect them.
Mm.
Sir, one doubt, sir. Is there any possibility for development rights not getting taxed? Because there's no
Impossible.
clear entry. Is there any
No, it
possibility,
is very
sir?
clear. 9972 is very clearly there.
Yes.
Impossible because, you know, in Bombay, in that Worli area, apartment selling price is 1.5 lakh per square feet. 1.5 lakh per square feet. Recently, Narayana Murthy purchased 50 crores he paid for that apartment. If 1/3 is good for Nariman Point, 1/3 is good for Bangalore, Mysore also.
Yes.
Okay, next one point I'll just mention for everyone to consider. There's a very interesting explanation in 3/19 as to what is development works. Now we have seen three things. Development rights we have seen, development charges we have seen, now development works. Development works is defined as internal development works and external development works. Internal development works is works carried out within the plot. External development works are works carried out outside, but for the enjoyment of the inside. Now, the rate of the plot will increase based on facilities provided. If only boundary wall, gate, watchman room, water tank, STP, ETP, electrification is provided, the plot will be 3,000. If they provide clubhouse, then the price will be 5,000. If they provide many other things, we have to only ask one question. The area of the clubhouse, is it also undivided share coming to the plot buyers, or that is sitting in the balance sheet of the developer? If we examine those facts, we will come to know, is it composite or non-composite supplies? Like Sujata madam was mentioning, school, hospital, theme park, many things may be there, but the land area consumed by these extra facilities, is it included within the rate per square foot, or is it separate? If we identify that, answer will become very evident. We have to only assume that all the pricing is included in the 10,000 per square feet. Otherwise, it will become difficult to have a discussion. When all these amenities are part of 10,000, then the answer is only simple. On outward supply, what tax you are going to pay will directly have a bearing on what tax you are liable to pay on the inward supply.
Sir, just to add on that, even in the 3119, the definition of that landowner promoter, they also have added the development of plot also, no, sir, like who is a developer. Yeah. So that also can bring some thought on that, sir.
No, but then if you are relying on that third
Then
proviso,
again,
then you are going against Godrej.
against voters. That's what, that was actually a reading when I was, yeah.
Sir, the last remarks what you made, like, the decision about the outward supply will have relevance to inward supply. Could you please explain it with a number example or something, sir?
No, ma, if on the outward, like see, Annapurna madam said on 10,000 rupees, no GST. Then on 100 crores, you have to pay 18. That is the obvious conclusion. Now, Sujata madam said on 10,000, I will pay 5, which means 100 crore is exempt.
How does the decision exempt this transfer of development rights, sir?
Madam, why do you pay 5,000 on a plot? If you see the definition of apartment, definition says shop, building, etc., which is a separate and independent part of an immovable property. In a 1 acre piece of land, a 30-40 site is a separate and independent part of that land. Common sense tells us that apartment is a dwelling unit, like a shop or a flat. But the definition does not seem to exclude it. Annapurna madam referred to the third proviso, where it talks about landowner promoter converting a land into plots. So even the 3/19 treats land different from plot. So therefore, combined reading tells us that an apartment is nothing but a smallest saleable unit in a project. Which is the smallest saleable unit in a RREP? A flat. Which is the smallest saleable unit in a plot project at 30-40 site? Which is the smallest saleable unit in an industrial layout? It is nothing but the industrial lands where above 30 years is exempt, below 30 years now KSIDC, MCD, Mumbai, everyone has started to pay GST. So therefore, the smallest unit, if you say, it falls within apartment, therefore RCM gets exempt.
Sir, one more aspect here, sir. If we are looking area sharing model and revenue sharing model, can we look into a different implication of forward charge and reverse charge, sir? If in case of area sharing, I was just trying to look because to save the interest, they have not paid from so many years. And here, there is no exchange of monetary consideration. There is a exchange of plots against the transfer of development rights. So, so 4/19 also, if I have to take into that, may also be not applicable, no, sir, because definitely 4/19 is quite clear on the aspect of apartment. So can we look into that aspect also, sir? Because 4/19 with the plot, if you look, it is very clearly given as an apartment in a project. So I
Correct.
think we may, so that is also one more thought, I thought. Yes.
Correct. If it's an apartment in a project, you have also got RERA approval.
Yes, yes, yes.
It's a separate and independent part of a project, of an immovable property. So therefore, you hit to pay.
Yes.
See, those who have not paid tax on development rights, the defense that can be taken is department is supposed to demand output tax on apartment sales. They cannot deny exemption on inward supplies. See, it is not like a passenger transport service where or GTA where 5% without ITC, 12% with ITC, etc. This is RCM. You
Yes, sir.
department can come and say, why you are not paying tax on development rights? The answer will be development rights are exempt from tax as per the scheme from 3/19 onwards. No, but then you have not paid tax on outward supply. But the show cause notice is not to pay tax on outward supply.
Yes, sir.
That's all.
So don't we think that there should be a separate notification or a specific clarification, especially in the case of this development agreements only for plotted developments?
Madam, I feel department
Hmm.
wants the levy tax.
Hmm.
Department has given that clarification to say that after completion there is no tax. After completion there was never any confusion about the tax liability. But if you see the legal rights and remedies flowing to the parties, very clear. Very clearly, the developer receives an interest in the memo property under 202. So therefore, there is a supply for which we are not able to give, we are not giving an answer.
Yes, sir.
Be a contractor.
Illa madam, a developer can never be a contractor. Developer will be having an interest in the property. 202 of contract law is an agency coupled with interest. We can never treat a developer who is acting under a registered JDA to be a contractor. Okay.
So, coming back to the basics again, like from pure law perspective, if we are, if we have to understand this whole aspect, and again from the advisory perspective, if everything is getting sold after the 100% CD release, then on the inward supply there is a full tax at 18%, sir.
Development rights has been supplied? Yes. Development rights has 18% rate of tax under 9972? Yes. What is the value that the landowner received? 100 crores.
Okay. If let's say 20% of it is sold before OC and 80% is sold after.
Madam, see, the reason why I took an example like this is for us to come to a conclusion. 80, 20, 79, 21, etc. We will keep arguing till the cows come home. The answer is we are not paying tax on inward and outward. That is where we are going wrong.
But then
On
why is
inward
it
and
confusing,
outward, we
sir?
are not paying tax.
That circular, is it given from the angle of owner of the landowner? And people are reading it as a developer and assuming that it is not, GST is not applicable, because that circular is giving clarity that if you are selling the land for leveling and all that, no GST, only development extra charges you pay only to that
No,
extent. That's what.
nobody knows whose point of view they're giving the circular, madam.
177 circular.
No, we don't know on whose point of view they're giving. Everybody is reading the way they want to read it. This girl is saying that boy is always looking at me. I think he likes me. That boy is having eyesight problem, so he is trying to look this side only. So this boy and girl are having all this confusion. So therefore, don't hang your hopes on circular. And clients are very smart. It is we only early morning sitting and having discussion. Clients have collected output tax and kept it, and RCM they are not paying tax. If anybody wants to pay tax, they will go to Sujata madam for opinion. When anybody doesn't want to pay tax, they will go to Deepak for opinion. We are prepared to give opinion. And notice comes on a totally different interpretation.
Sir, one of the client has made a provision itself for this taxation in the case of plotted development with interest, sir. When he has
Now, when they make a provision, it's a very, very dangerous thing.
yes, sir. That is more risky actually. But I've
Madam,
seen few of them.
No,
Yes.
no show cause also, directly bank attachment.
Yes. Yeah, that is also we should be careful, sir, when because few clients are not aware of that implication and they directly think that it is on litigation, so we'll make a provision. So I think that also we have to be quite clear on that.
They should not make provision. They can't, it's not even something where they have to disclose contingent liability.
Yes, sir.
Sir, how direct bank attachment, sir? 76 al ಬರ್ಬೇಕಲ್ವಾ sir?
You are only saying that you have a liability that is undischarged. Why they can't attach bank?
75/12 ಅಲ್ವಾ sir?
75/12 ಅಲ್ಲ, 75/12 ತಗೋಬಹುದು. They can take very, very dangerous.
And many instances, what has happened, projects are over, sir. It has been like 3 years, 4 years back, the project is completed. Now they are receiving the notices from department. So now,
74 only.
yeah. So again, the issue is 74.
See, first of all, as professionals, we need to be very clear. We should not take over the client's headache.
Yes, sir.
Clients have taken a commercial call.
Mm.
No client will pass on the tax benefit to the customer and suffer a notice. If a notice can come, he will collect the money, keep in FD, invest it somewhere, and then take the risk of litigation. Nobody is completely unprotected from GST litigation.
Yes, sir.
Thank you so
Okay,
much for
next session illuante.
Thank you for your valuable input, sir. I thank all the members of this forum for giving this opportunity. Thank you so much. So probably I will come out with whatever views we have discussed here to get some finality and also the way forward for advising their clients. Is that fine, sir?
Right.
Awesome. Thank you. Thank you.
Thank you.
Thank you so much. Thank you.
Thank you, sir. Thank you. Thank you all.
Thank you.